Among the many contentious issues regarding patents and patent litigation, one that's really not in dispute is the fact that the award of a patent confers the power to exclude. And along with that exclusionary power comes monopoly power. And as you know, in antitrust theory, the possession of a monopoly is not inherently unlawful. However, just like in controversies where patents are not at issue, competition laws and regulations may come into play depending upon how that monopoly is maintained and utilized. Concerns expressed to the Federal Trade Commission over the assertion of patents' power to exclude by certain entities led the Commission to hold a heavily attended workshop last December. That workshop on what the FTC terms patent assertion entities led to a period of public comment. The debate over patent assertion practices and alleged litigation abuses has spread to Congress and even to some state governments. I wanted to say that, given the moniker that sometimes is used in these debates, I thought it would be appropriate to make a reference to, or paraphrase, I guess I should say, the statement of a famous child and film star, Shrek, to say that the PAE debate is kind of like an onion. Just keep peeling that onion, layers and layers of it, and the complexities continue to emanate from that onion that is known as the PAE debate. So with that wonderful image in mind, I'm going to introduce our speakers in the order in which they will present, and I will get out of the way. If you have questions, those of you who are online, you can email them to us at interactive@wlf.org during our program. I also understand that one of our attendees today is going to be live tweeting the event. It's at Patent Progress if you'd like to follow along with that. And as I said, if you have questions, please send them in and we'll hopefully get a chance to ask them. Leading off today is Lisa Kimmel, who's the Attorney Advisor on Antitrust Law and Competition Policy in the Office of Chairwoman Edith Ramirez at the Federal Trade Commission. Ms. Kimmel has served as the Chairwoman's lead advisor on antitrust and competition policy issues related to intellectual property rights since joining the Commission in May 2010. Speaking second will be Thomas Ewing, who's an attorney and counselor on intellectual property law and business with Avancept LLC, a strategic IP consulting firm. Mr. Ewing routinely advises international organizations, government agencies, universities, law firms, multinational corporations, and financial institutions on intellectual property issues. Finishing up today will be Lonnie Rosenwald, who's Chief Counsel for Innovation, Science, and Development at Intellectual Ventures. She joined the firm in 2008. Prior to that, she was Chief Operating Officer for Azlestar Incorporated, Senior Vice President and General Counsel for Blue Frog Media Incorporated, and Vice President of Corporate Development for AT&T Wireless. If you could get us started, Lisa?
Sure, thank you. Oh, hi, good morning, everybody. I want to thank Glenn and the Washington Legal Foundation for the opportunity to participate in this program today on antitrust and patent assertion entities. And I'm very pleased especially to be here with Tom Ewing and Lonnie Rosenwald, who are really experts on this sector. I'm an antitrust lawyer primarily, but these guys both have really deep expertise on these issues, and I'm very interested to hear their perspectives on the role of antitrust in this sector. And I want to make clear that I'm here today in my individual capacity, and the comments that I make don't necessarily reflect those of the Federal Trade Commission or any individual commissioner, including in particular Chairwoman Ramirez, my boss. So the program title today references the FTC DOJ inquiry and underlying legal and policy issues. And my job to open this program is to say a little bit about the FTC DOJ inquiry. So with a view to that assignment, I want to just touch very briefly on 3 questions, and I'm going to try to move a little quickly so we have lots of times for Q&A. So the first, I want to make sure that we're all on the same page with what we mean by the term patent assertion entity. It's just a definitional issue. It seems somewhat obvious, but those who are familiar with the literature in this area know that even this starting point is the subject of some amount of debate and controversy. Second, I want to say a little bit about the FTC's background on these issues and a little bit of the work that we've done. And finally, I want to talk a little bit about what's going on now at the agency with regard to patent assertion entities broadly and antitrust more narrowly. So what do we mean by the term patent assertion entities? In its 2011 report on the IP marketplace, the FTC defined a patent assertion entity as a firm with a business model that's focused primarily on purchasing and asserting patents, typically against operating companies with products currently on the market. The Commission distinguished PAEs from the more traditional non-practicing entity, or NPE, which usually refers to an organization like a university or a research and design firm that uses patents to support a business model based on developing and transferring technology. Of course, the purpose of drawing this distinction in the report at that time was to focus attention on what seemed to be an increasingly important, rather new actor in the IP marketplace, and to raise and to begin to answer a number of questions regarding the impact of PAEs on competition and innovation. More recently, some scholars and industry experts have started to use the term patent monetizer to describe NPEs that are not involved in research and development or products or technology transfer. The term, I think, is pretty much the same, means sort of the same thing. The definition, my understanding, if you see the term patent monetizer, it's a little bit broader than what the FTC referred to as a patent assertion entity, because it also covers entities that may be in the business primarily of monetizing patents, but they may not assert them directly themselves and may transfer them to third parties. But it's also a very good term, maybe a little more accurate, but I think it's sort of largely trying to capture the same sort of an actor. Definitions matter. They matter for empirical work because I think you'll probably see there's a lot of studies out there starting to look at litigation statistics. And so if you're you want to make sure that you're comparing entities that are essentially being defined similarly if you're looking at the growth of litigation or trying to compare what's going on in the courts. At the same time, some have criticized academics and the agency perhaps for focusing a little too much on the nature of the actor, and then they sort of urge policymakers to really focus on the conduct rather than the particular business model at issue. And that may be something that we want to talk a little bit more about today. In the Commission's 2011 report, it really did a little bit of both. First, it did really take a little bit of a dive into just the actual business model of the patent assertion entities, which at the time they were putting together the report was still a relatively new phenomenon, trying to understand the different types of actors on the market and trying to also sort of parse a little bit of what was then available in terms of data on litigation activity by these actors. But ultimately, the Commission really concluded that PAEs, in that report in any event, PAEs were primarily a response to flaws in the patent system, particularly related to poor notice and a system of remedies that did not reliably align the economic reward and the economic contribution of a patent. And all of the policy recommendations that the Commission made at that time were directed at improving the patent system. It did not at that time make any recommendations specifically directed at the particular type of business organization. Whether that's the right approach or not remains to be seen, one of the questions we might discuss a little bit. And also, if we're, another thing that's been coming up recently is if we are thinking about antitrust, it is useful probably to understand a little bit more about these particular businesses if we want to think about whether there's a relevant market for the particular services they provide, who else is in that relevant market, is the relevant market changing, and those sorts of questions, in which case it's useful to understand more about the firms themselves because, like I say, these are relatively new actors in the marketplace. So moving on from definitions, why is the FTC interested in PAEs as a policy matter? Taking a little bit of a step back, the FTC has a long history of an interest in research and advocacy on the patent system. The agency typically describes itself as taking a competition policy perspective on patent law, and all that really means is it tries to take the same sort of economically grounded, incentive-based approach to patent law that it takes when it's looking at antitrust issues, and that courts and agencies around the world increasingly adopt when they're looking at antitrust issues. And the emphasis when the FTC is looking at the patent system is on competition, innovation, and consumers. That's our job. So the roots of the FTC's interest in this particular subject of patent assertion entities began with a series of workshops in 2008 and 2009 focused on the patent system, again, focused particularly on issues of notice and remedies. The information from these hearings was what provided the basis for the Commission's 2011 report, where the Commission did take its first serious look at the rise of patent assertion entities. The evidence in that report suggested that PAE activity was on the rise, and at least suggested that it was imposing a meaningful tax on innovation, particularly in the IT sector. what some refer to as a tax on innovation. Okay, so since the report, other academics have continued to mine the litigation data in particular, and there's a lot more evidence available now. And though the statistics do seem to differ somewhat across researchers, which seems to depend on the data set they use and how they define the bucket of entities that they're looking at, the trend at least seems pretty clear that PAEs seem to be responsible, that patent litigation is growing, and that PAEs seem to be responsible for an increasing share of that litigation activity. The litigation data is, of course, just the tip of the iceberg. There's a lot more going on probably outside the courtroom than going on inside the courtroom, but unfortunately we don't have very much data on what's going on outside the courtroom. There's no real reason to think that the trends are different, that PAs are somehow responsible for less patent assertions outside that never make it into litigation, but we really just don't know. The data and the anecdotal evidence that we do have do suggest that PAE activity is on the rise and is adding to the cost of doing business, like I said, particularly in the IT sector, but apparently also increasingly in the retail sector, particularly the online retail sector. Now, litigation costs or costs alone don't necessarily suggest there's any sort of a problem. There could be countervailing benefits, and some claim that PAEs encourage innovation by, for example, making it possible for small inventors to license their technology, getting a reward for the time they put into creating their inventions. Or another suggestion is that it provides a sort of type of insurance to the startup community, so if the startup fails, they can, there's a market available for its patents, which then can sort of recycle the money back into the startup area. So the FTC has in the past expressed what I would call some skepticism that these benefits were sufficient to overcome the evidence that they saw of potential drag on innovation. And I think at the recent workshop that Glenn mentioned in December, which was a joint workshop with the Department of Justice Antitrust Division, I think it's fair to say that skepticism was kind of the prevailing sentiment. But that's the core question, and that's what the FTC and most of the researchers are really trying to get at, is what is overall the impact on the economy from this activity? Is it in total going to be going to encourage innovation, or is it ultimately just going to be more of a drag on innovation, competition, and consumers? So what's the FTC doing now? And most of the emphasis is on the workshop that we held with the Department of Justice last December. The workshop was just one part of a broad fact-finding exercise by both agencies. The bulk of the program was devoted to trying to get in various ways at that core question about the costs and benefits of PAE activities that I just mentioned. And we did both the agencies had a lengthy comment period, which is now closed, and we received nearly 70 submissions from interested parties, large and small companies that have been the target of PAE activities, as well as companies that claim that PAEs are generating important efficiencies in the market. Both agencies are continuing to meet with various stakeholders on these questions, and they're really, at this point, considering what the next steps in the process. Now, the focus today is purportedly about is PAEs and antitrust, and whether antitrust has a meaningful role to play in this sector. And of course, the antitrust laws apply to PAE activity just the same way they apply to all other, activity or most other activity in the marketplace. So, for example, if a PAE sells a large patent portfolio to an operating company, that raises somewhat traditional antitrust questions. We might think about vertical issues, foreclosure issues. We might think about horizontal issues in technology markets. These are kind of standard questions. The fact that there's this particular type of actor involved in the transaction, I don't think really changes the antitrust analysis very much. Two companies, they're all hypos. If two companies were to transfer patents to a PAE and they retained a controlling interest in that entity, and then that entity were to sort of maybe refuse to license a third competitor, we have a concentrated market, that would raise red flags, probably. We don't know really what the analysis would be, but that's, again, sort of a traditional antitrust question. I don't think the fact that a PAE is in the middle really changes the thinking about it all that much. But the more challenging questions really seem to be the role of antitrust in what we would call the sort of core PAE activity, which is acquiring and asserting patents, not necessarily involving competitors. Again, there's sort of a standard role for antitrust in just analyzing patent acquisitions. There's always issues of, technology markets and whether the acquisition leads to market power in a technology market. As a matter of principles, it's fairly easy to understand. Practically, it might be quite difficult if there's a large portfolio license. It seems to me that more difficult questions there are practical ones than theoretical ones. But in general, when we move beyond that, the role of antitrust in core PA activities is not at all obvious. There have been some very interesting questions raised about whether a transfer that allows a company to escape the risk of mutually assured destruction, whether that creates an antitrust issue, or opinions kind of differ on those sort of things, and I actually don't really have an opinion at this point. But what I would like to do before I close up is just, as Glenn said, the FTC and DOJ did hold a really excellent workshop in December, and the video from that is available on the FTC website. And the very final panel on that was focused pretty much exclusively on these kinds of novel antitrust questions that are sort of swirling around PAE activity. And it was a really first-rate panel of economists and lawyers. And they raised and discussed a lot of interesting questions. It was a very thoughtful discussion, and it was surprisingly good theater for an antitrust panel, for those of you who saw it. So I would highly recommend that. And with that, so that's kind of a snapshot of what we're doing, and thank you very much, and I'm really looking forward to what everyone else has to say. Thank you. Oh, sure, please.
Thank you for inviting me to speak on this interesting and complicated topic. I greatly appreciate the leadership of the Washington Legal Foundation and the FTC and DOJ in this area. I'm also mindful that patents are somewhat of an obscure area, as Justice Scalia himself conceded not so long ago. The most boring case he ever heard was one involving patents. The patent trolling business, as it were, is perhaps somewhat more exciting, and it is also an American-only phenomenon. It exists a tiny bit in China, a tiny bit in Holland, and a tiny bit in Germany, but it does not exist at all in the United Kingdom, Sweden, Norway, Switzerland, France, Austria, Australia, or any other country having a similar GDP to ours. This is an American-only phenomenon. Now, in terms of definitions, I agree there are a number of definitions floating around. They're all somewhat synonymous. I prefer the term monetizers, PAEs, MPEs, trolls. As Chief Judge Rader of the Federal Circuit has said, labels are not helpful. So let's look at conduct. First of all, the entire monetizer business is driven by a litigation asymmetry, and the litigation asymmetry is this. When two companies sue each other for patent infringement, there is a great likelihood that the defendant company will file a countersuit. This has a tendency to dampen litigation among companies to that set of patents for which each side believes is truly infringed by the other. There is very little speculation in the patent business among companies themselves. This does not exist in the monetizer community. Monetizers can't be sued for patent infringement because they make nothing. So therefore, this one countervailing portion of our patent legal system does not exist for the monetizers. So again, what conducts of the monetizers are we talking about? Well, first of all, the conduct of demanding a license without the possibility of accepting a response of, no, I don't need a license, here's why. Many monetizers refuse to discuss the merits of the ultimate infringement with the companies that they assert their patents against in a litigation context. There is in the litigation business the phrase, you eat what you kill, meaning once you've received a demand letter from a patent assertion entity, they have a tendency not to go away without receiving something from you. There's also the conduct of stretching patent claims in licensing and litigation beyond a reasonable scope, the conduct of asserting dodgy patents with narrow claims. the conduct of asserting patents that have been committed to standards organizations by a previous owner, but committed to those standards organizations in such a way that it is difficult to determine that that specific patent was committed to the standards body. Then there's also the shadowy organizations hidden in webs of shell companies that make it difficult to determine who the real party and interest is behind the litigation, which again goes back to that litigation asymmetry that I mentioned. Then there are agreements, or the appearance of agreements, between companies and monetizers regarding actions to take against their competitors. Agreements between multiple companies and monetizers regarding actions to take against groups of competitors. Agreements or the appearance of agreements between companies, financiers, and monetizers regarding actions to take against other groups of competitors. All of these comprise patent privateers, a term I coined several years ago, that takes as a metaphor the historic method of waging war on the high seas, in which the crown grants a pirate a license to attack its enemies. I think President Obama might have said it best when he referred to trolls don't actually produce anything themselves. They are essentially trying to leverage and hijack somebody else's idea and see if they can extort money out of them. Now here's a simple test. It might be too simple, but for me it pretty much separates one group of licensors from another group of licensors, and that is, can the monetizer meaningfully, or can the prospective licensor meaningfully grant a technology license? What is a technology license? Technology license is a license based on one's learnings in developing a product and putting the product in the stream of commerce. Not one single monetizer is capable of granting such a license. They own legal rights and nothing more. So let's take it, for example, the licenses that Toyota grants for its regenerative brakes. Toyota developed regenerative braking technology, but it licenses that technology to other competitors. And along with that license, Toyota provides its learnings. In contrast, a typical monetizer has purchased legal rights. They know nothing about, or very little about, the underlying patents or how to make a product based on those patents. It's a license purely of a legal right, which we will discuss in a moment. But first I want to talk a little bit about the fuel. Almost all the conversation about monetizers is about the fire. Let's talk about the fuel. The fuel is U.S. patents. October 7th, 1980, a little more than 32 years ago. What's important about that date? October 7th, 1980. That's the date that marks the halfway point for all U.S. patents that have ever been granted. Half of all U.S. patents were granted before 1980. We started granting patents in 1790. So you have 190 years on one side of a line and 33 years on the other. That 190 years contains the inventions of Edison, Tesla, Bell, Fulton, Salk, the Apollo program, and all the heroes of invention that we learned about in school. Yes, we have more R&D funding nowadays, so that explains a portion of the surge. But any patent attorney will tell you that his clients simply file more patent applications nowadays. 1960, we granted 47,000 patents. 1970, 64,000. 1980, 61,000. 1990, 90,000. 2000, 157,500. 2010, 219,500. Last year, 2012, 253,155 patents. The present rate is more than 1 million new patents every 4 years. Bear in mind, it took 121 years to grant the first 1 million patents. We either have a lot of geniuses today, or it's become much easier to get a patent. Patent granting rates this high are completely inconsistent with the U.S. system for litigating patents. We have the most elaborate and complex system for litigating patents in the entire world. It is also the most expensive. And this is the basis behind the monetizer business. Let me just give an example. Oftentimes people talk about software patents as being the problem. Personally, I don't find software patents terribly problematic or any more problematic than other kinds of patents. So let's take something that is totally non-software, antennas. From 1978 to 2000, 22 years, the Patent Office granted 8,000 patents on antennas. From 2000 to 2012, just 12 years, the Patent Office granted 13,500 patents on antennas. It's nearly twice the number of patents in a significantly shorter period of time. So, to be clear, with all those patents around, it's not all that difficult to find a patent that's arguably infringed, and that's all that's necessary for a monetizer to win a settlement. Bear in mind, however, 76% of all patent infringement lawsuits settle. Most corporate executives are fearful of fighting battles all the way to the end for fear of unintended consequences. Injunctions are possible. Excessive damages are possible. Management distraction during a patent litigation is absolutely assured. But what happens when they stick it out? Statistics show that monetizers tend to lose, and lose often. Let me take the example of Oasis Research. This was a company featured in an NPR report 2 years ago titled When Patents Attack. Dozens of companies were forced to license Oasis's patents. Of the 17 countries ultimately sued by Oasis for infringement, all of them settled during litigation but 2. And what happened to the two companies that stuck it out? The jury found the patents invalid. There is some evidence that licensing fees were on the order of $20 million per company. Now you can imagine that that probably means that several hundreds of millions of dollars flowed in one direction that legally were not required to pass. To be clear, I am not anti-patent or anti-intellectual property. I have worked in this field for 24 years, starting first at Caltech and NASA JPL. I have personally trained scientists and engineers from 45 countries in how to be patent agents. I come as a friend to the IP community, and I come as a friend to say the present situation will not stand. It will be changed. It's just a question of when. Professor Robin Feldman, Sarah Giroux, and I, in doing a follow-up study for the American Invents Act, have recently determined that presently more than 50% of all patent cases are brought by monetizers. Our findings are very similar to those of RPX, Patent Freedom, and others. But again, 76% of all cases settle, which means our federal judges are being used essentially to conduct licensing negotiations. And that's a horrible waste of our federal judiciary. I believe we should finish out the legal infrastructure in the patent field. Patents are a unique market that call for unique regulation. The patent market calls for unique regulation. Why? Because it is a completely artificial market created solely on the basis of government-granted rights. No patent office, no patents, no market. Airplanes fly whether we regulate them or not. Farmers raise crops whether we regulate them or not. People possess land whether we regulate it or not. No one owns a U.S. patent without the U.S. patent law, without action by the U.S. Patent and Trademark Office. This is a market enabled by society and entirely by we the people of the United States. And it's a good thing that we have patents, but we have every right and every duty to shape that market so that it achieves the goals we have for it. And what are those goals? We seldom articulate them, but I believe that comes down to stimulating new American invention and not hobbling it. The question to ask is, should vast amounts of capital be diverted from funding new R&D efforts, new companies, new skills, new capabilities, and diverted instead to speculative schemes involving buying old, unused, unpracticed patents? I don't think so. As has been mentioned, the DOJ and the FTC are trying to understand what is below the waterline of a giant litigation iceberg. Even in litigation, we know less and less because more of the papers filed in litigations are sealed nowadays than in the past. In fact, an attorney in a patent case in a motion last year said the patent litigation was none of the public's business. I couldn't disagree more. Patent litigation, licensing, and assertion are entirely the public's business. We granted these rights. We have a right to know everything about them. And we need to know more. We need to understand the labyrinth of shell companies that have been constructed to hide real parties and interests, to hide who's financing patent monetization. Among other things, we have no idea how many truly independent actors there are in the patent market. Evidence suggests there are far fewer of them as independent actors than a superficial overview would suggest. I'm aware of one company that was sued by 80 monetizers in 18 months, and it turned out that 30 of those monetizers were actually related to each other. The efforts to reform our system have been ongoing for a number of years, but more action is required. In fact, the states themselves are getting anxious. Vermont's legislature recently enacted the nation's first anti-patent trolling statute. Vermont's Attorney General has sued a patent troll, one that operates in Vermont using some 40 shell companies, using Vermont's consumer protection statutes which prohibit unfair and deceptive acts in commerce. That Attorney General's office was apparently concerned about letters received by small business owners in Vermont. So in conclusion, we have a serious problem about monetizers, and statistics show that it's getting worse. Huge amounts of capital are presently being routed to an artificial market that cannot and will not stand. But we need to have our industry, and we do not need to have our consumers and industry hobbled by rights that we have granted. But the present challenges pose a golden opportunity for getting things right, for finishing the parts of our innovation system that will sustain and promote American industry for this generation and beyond. I'm sure that in the end we will do the right thing. Thank you very much.
Thank you, Tom. Lonnie?
Good morning. I'm Lonnie Rosenwald, as you said, the Chief Counsel for Invention, Science, and Development at Intellectual Ventures. And thank you very much for inviting me to the panel today, and I'm very happy to be here. In terms of the government scrutiny of this industry, we don't have any problem with that. We participated in the workshop, and we were with Lisa and some of her colleagues yesterday. But the question we would have is, what is the problem, and are the proposed solutions that are being examined likely to address that problem? And we do believe that the focus should very much be on the behavior and not on the nature of the entities. Now, when you speak about NPEs, as I think was pointed out, that's a very broad category that involves a lot of different types of entities, including universities, research institutes, garage inventors, companies like ourselves which don't create products, as well as a lot of product companies that are seeking to monetize patents and other technology that they're not practicing for a variety of reasons, or companies that started out and failed in the product market and are now seeking just to monetize their intellectual property portfolio. So patent assertion entities also comprises many of those same players, product companies being among the most active of the patent assertion entities. So what are some of the benefits of patent assertion entities or the benefits of non-practicing entities? Well, there are many. NPEs perform many valuable functions. For one thing, they perform a one-stop shopping location for companies that are seeking to acquire intellectual property rights. You can imagine with today's very complex products, it's really almost impossible for a company to own all the intellectual property rights. It has been said that a smartphone, for example, has perhaps 250,000 different inventions in it. So it would be highly inefficient for a company to have to go and meet with the individual inventors of all those patent rights. Secondly, they, as I think was mentioned by another speaker, provide incentives for inventors, and we have provided hundreds of millions of dollars in payments to inventors. So we stimulate invention. Secondly, we as a company have launched a number of new technologies into the marketplace. In 2008, we created TerraPower, which is a nuclear power company that's designing a fourth-generation nuclear power plant, which solves a number of existing problems in the nuclear power industry today, such as it creates a minimal amount of nuclear waste. It essentially solves the non-proliferation problem. Another example, in 2012 we launched Kymeta, which is a novel mobile satellite antenna company, and in January MIT named Kymeta one of the 50 disruptive companies in the world. A couple of months ago we launched another company with a European company. We are trying to license and monetize and develop further some cattle nutrition products that improve the speed at which cows produce milk. And then we have another project called the Global Good Project, which is trying to solve a number of problems in the developing world, such as malaria, keeping vaccines cold, clean water, and nutrition. So we have provided a number of technologies that didn't exist before. So another point I would make is the idea of hobbling or even outlawing patent assertion entities. It's just not going to happen for one reason, because as I said, there are a number of companies, even product companies, that are acting like patent assertion entities. And really the genie is out of the bottle on this. The value of patents has been realized in the marketplace. And so the focus can be and should be on practices that we think are damaging innovation. So what are those practices? And many of these tech practices that have been mentioned by my fellow panelists are ones, by the way, that Intellectual Ventures doesn't engage in, but I'll go through some of them. First of all, we have not filed a great deal of litigation. We've filed 16 lawsuits, and we have never sued a small company. Every single company that we have sued has been infringing high-quality patents. These are all large, sophisticated, publicly traded companies with hundreds of millions of dollars in revenue. We've never sued anyone anonymously. All of our targets know who we are. And what do small companies think the problem is? Well, the small companies we talk to say the problem is infringement of their intellectual property rights by large product companies. And these small companies don't have the financial or other wherewithal to go out and do anything about it. And that's what's really quashing innovation. But there's not a lot of focus on infringement. The focus has always been shifted to assertion entities. But I really think we should focus on intellectual property rights, protection of intellectual property, which is really the crowning jewel of the United States economy. And if we talk about the increase in litigation, perhaps we should look into whether that is a function of an increase in infringement. That's an area that I think should be studied. The regulation that we find is most likely to be imposed would be transparency, or a requirement of disclosing the true party and interest. This is seeking to address a problem that we think doesn't exist. It is simply not true that product companies are looking to find us. If they were, they could go to the patent office searchable database and they could find out who owns the rights to the patents in their products. And they could call us up and say, we would like to take a license. That never happens in practice. We are always the ones who approach companies that are infringing our patents, and of course they know who we are when we approach them. But we do think it's an interesting idea, and transparency would be valuable in the context of a requirement that product companies would have to do sort of an intellectual property audit before they put a product on the market. And in that case, it would be similar to an FDA approval process, where you have to pass safety review before you sell a drug or certain kinds of food. In that case, if the companies were actually trying to find out who owned the intellectual property in their products, it would make sense to have the true party and interest disclosure requirement. But as I said before, companies never try to find us. We always approach them. If they did want to find us, there's a pretty easy way to do it. I think there is some common ground here, though, in terms of trying to find a more effective way to ensure that we do have high-quality patents. And certainly one solution to that, and something we have been in favor of for a long time, is more funding for the PTO. Another solution, which was recently enacted, the America Invents Act. There were lots of aspects of that law that we liked. There were a few we didn't like, but on balance we thought it was a pretty good law. But it's brand new, and it needs to have some time to take effect so that we can evaluate it before we go and consider major new legislation. So let's give that law a chance. So summarizing these points, transparency really is a solution seeking a problem that we think doesn't exist. Non-practicing entities or patent assertion entities aren't the problem, and in fact do provide a number of benefits such as incentivizing invention, one-stop shopping, launching new technologies into the marketplace. The real problem, which doesn't get enough attention, is infringement, something that a lot of powerful players don't really want to talk about, but which is the real threat to emerging companies and therefore our economy. In terms of the tax on innovation, which Lisa talked about, I would argue that infringement is the tax on innovation, and to the extent it stifles new businesses, we're losing the opportunity to launch even more economic activity in the United States. And in terms of the costs, there are hidden costs even when you don't have litigation, because product companies are typically cross-licensing, and therefore they're losing an opportunity to monetize patents. But that's something that's not visible. There's no dollar figure associated with those transactions, simply a cross-license. I wanted to address a couple of Tom's points, and by the way, Tom has written a lot about intellectual ventures, and part of his business is to sell lists of entities that supposedly we operate, but you've never contacted us, and we would just love to have you come out and visit us in Seattle, and we can show you what we do and show you a lot of our innovations. So,
as long as I don't have to sign your NDA, I'm happy to come.
We do have lots of visitors who don't sign our NDAs. I guess the last point I wanted to address that was made was this whole idea that there was a lot of invention before 1980, and now there are a lot of patents and not a lot of inventors. I think there are obviously a lot of reasons for that. A lot of today's products are very complicated. They don't have a single famous inventor like a Thomas Edison or a Tesla. But I would like to see the statistics that represent the number of patents is not a reflection of a really vibrant market for invention. In fact, the United States economy, Silicon Valley, which is an inventive hub of the world, is really the envy of the world, and people from other countries travel here all the time. They come into our education system, they work in the Silicon Valley, so that, and they ask, how can we create something like this? So, the fact that we have more and more patents all the time means we have more and more inventions all the time. It means that we have the strongest inventive economy on earth. And I don't think we should do anything at all to endanger that. If we have invalid patents, then we should be focusing on the percentage of patents that are being granted and perhaps thinking about more funding for the patent office. But the mere fact alone we have more patents, I wouldn't apologize for that to anyone in the world. And I did want to make one other point in terms of litigation. A number of the countries that, well, first of all, the United States has more litigation in general than any country in the world. This is not in any way limited to patent litigation. It's a function of a lot of things about our legal system, chiefly the fact that we have punitive damages. And a number of the countries that were cited of having less patent litigation, Sweden and so on, they don't have that many patents. And again, I think this is something that we should be very proud of in the United States and should do nothing at all to try to hobble. So I'll leave it at that so that we can get to the questions.
Thank you to each of you for your opening thoughts. I'm going to open it up to questions from the audience, and if you could identify yourself and the question that you're directing to the person you're directing it to, or you'll be handed a microphone. It's for the benefit of our online viewers. And does anyone have any questions? Yes.
Thank you. My name is Dan O'Connor. I'm the Director of Public Policy at the Computer Communications Industry Association. I guess this is directed at Ronnie and then Tom, or Ms. Kimball can chime in as well. You talked about facilitating a kind of a secondary market where you're a one-stop shop for patent rights, but then you said nobody ever comes to you beforehand. You have to find everybody who's infringing. It's implied that rarely do people say, hey, come up to you beforehand and say, we're interested in this technology. Can we talk about licensing it? That was what I took from that. Usually when you're talking about technology transfer and providing some sort of efficient secondary market function, it's not just a license of patents, it's providing expertise. You're looking at companies like ARM who actually have their technology included in almost every smartphone out there. They're sending over engineers and technical diagrams. So some of the intellectual ventures, admittedly because you're out there a lot talking about these things, or other companies, in their promotional material, when they're talking about themselves, they say they facilitate this transfer of technology. Can you comment more on how you facilitate the transfer of technology besides just asserting patent rights?
Do I need that microphone?
You can.
Oh, okay. Sure. What I should have said is, in terms of the broad portfolio licenses and assertion licensing, that's where we never have anyone approach us. But we do have a lot of companies that have approached us and asked for exclusive licenses to a particular technology that they want to productize. And the difference is a company that is not infringing yet but wants to go into an area and wants the technology rights versus companies that are infringing already and are not out asking us for licenses. So in the case of the former, which I should have mentioned, we certainly do license more than just the patents. We license the know-how to the extent we have it. We are not a product-producing company. We do a certain amount of prototyping. We have a large lab where that takes place. And in those cases, and certainly in our nuclear spin-out and our antenna spin-out and a lot of the Global Good Fund projects, we transfer a lot of know-how and also provide ongoing consulting services, as you mentioned.
I guess I would say that, there are 2 million active U.S. patents right now, and it's a pure legal fiction that anyone could sort through them to figure out which ones they need. And even if you did that, there are two other problems. One is a willful infringement problem. So if you go looking through the patent database and find something, you might be later accused of willfully infringing it if you didn't then obtain a license. And there's the other problem, which is claim scope. It's very hard to determine what the scope of many patent claims are. The patent owner might think one thing, you might think another. Looking through the file history, you might yet think another thing. So that's the problem. 2 million patents. There's just too many to sort through, and there's just way too much uncertainty. I should also point out, having lived in Sweden for 5 years, Ericsson is a Swedish company, ABB is a Swedish company, AstraZeneca is a Swedish company, Akzo Nobel is a Swedish company, Volvo is a Swedish company, and SKF are Swedish companies, and they all have plenty of patents.
Other questions? I guess I'll invoke my right as the ability to ask a question. Lisa, is one of the things that's been a lot of comment on is the use of the 6B process at FTC and whether there might be a study under that. Is that something you can comment on, or is that still under discussion at the Commission?
I mean, it's definitely something we've heard. There were, in the comments received, that there were parties who were urging us that, and I think we're considering all the recommendations that we received.
Okay. Do either of our speakers have any thoughts on the availability of a 6B?
Or the contours.
Or the contours of it?
Well, I mean, I think in general, what I would suggest you do first is discover what the landscape truly looks like, because no one, to my knowledge, has a God's eye view over the entire U.S. licensing system. And I think were someone to have that kind of overview, all kinds of causes of action might be suggested, or perhaps not.
Questions? Yes.
Thanks. Deborah White, General Counsel of the Retail Industry Leaders Association. We represent a lot of large and innovative retailers in the United States, and our members have come to us noticing an increase in the patent litigation that's filed against them as end users. And what we've heard is that this does in fact stifle innovation because they've become more risk averse. They're much less likely to try new inventions, to try to get online or to do other things because of the huge costs, largely due to the asymmetrical discovery and the way that the litigation system is set up for them. And I wonder if the three panelists would comment on that phenomenon and what you might see as a potential solution to that issue.
You know, as I mentioned before, we have never sued any small players and wouldn't.
We represent Walmart, Target, Costco. Do you sue end users or just?
Well, I think we could sue an end user. My point would be, though, that any target of our litigation, first of all, has been, you know, a subject of an attempt at protracted licensing negotiations. They're all infringing valid patents, and we firmly believe that people should pay to use other people's property, and they all have the wherewithal to defend themselves. And, you know, if we ask for a license from a company and they're not infringing the patents, they are not going to pay the license fees. The people that we talk to are not just going to roll over and settle to avoid litigation. If we're in litigation with someone or someone takes a license from us, they are infringing a strong, high-quality patent. So I know that doesn't exactly answer your question. I think we would ask for a license from an end user if they were infringing a patent, but we don't go after small retailers that don't have the wherewithal to defend themselves or pay for a license.
Tom, Lisa, any thoughts?
Sure. Yeah, there has been a trend to go after end users for a couple of reasons. One is generally the claims are worth more. A claim that to your supplier, to their suppliers, might be worth X, might be worth 3X because of the use that the end user makes of it. Many companies include in patent indemnity clauses in their agreements with suppliers, which is a solution. It's not a solution to the problem, but it might be a solution to an individual retailer's problem. And the other portion of that exploitation is from time to time monetizers look for patent newbies. So to sue the suppliers might be going into a game where the person you're going against knows the game very well. If you exploit patents against someone who doesn't know the game very well, you can extract millions before they figure the game out, and that's happened before. The other thing I would suggest is, as I said, I am aware of one company that was sued by 80 monetizers and discovered that 30 of them were related. So my suggestion is that your retailers attempt to find out who actually is suing them and then seek a comprehensive settlement with the ultimate party in interest rather than dealing with them onesie-twosies. It will be far more expensive that way.
Lisa, were any of those kind of concerns raised with the Commission or the Justice Department in your panel workshop or in the comments?
Sure, yes. And many of the comments we've heard, I mean, you know, what we saw in some of the public comments was somewhat of a shift. I don't know if it involves intellectual ventures or not, but of sort of patent assertion entities going after end users, particularly in the retail space, retailers that are moving into the internet sector. And that seems to be a trend. I don't know if I have any real evidence of that, but we certainly are hearing more about that now than we did maybe a couple of years ago. And it's you know, all I can say is it's a tough problem. I mean, each case is, you know, you can't really, I mean, in the aggregate, there does seem to be some important policy questions, but in terms of any individual case has to be looked at, you know, on the merits of the particular assertions at issue and so forth.
One other point, I mean, I would assume you have a very diverse membership, and I don't know if, for example, Amazon is a member of your organization, but there's a retailer that has its own patents that it has successfully asserted, the one-click patent being the most famous, so and that's really kind of the foundation of their business. So I think, you know, we have to be careful when we make broad brush statements, but I would assume that within your membership there's some diversity of opinion, and there are also patent holders who, you know, want a strong patent system and have perhaps availed themselves of the ability to license and assert their technology also.
Comments about my membership, I'd like to respond. Yeah, of course, we have a very diverse membership, but I think the fact that there does seem to be an unequal playing field in terms of the litigation is something that universally they would agree upon that needs to be rectified.
One of the things that Tom had referenced was the involvement of Vermont in some of this, and one of the things that's happened in Vermont recently is the State Attorney General filed suit under their consumer protection laws against one of the patent assertion entities that's going after end users. Do you see that as something that's going to happen more frequently? Or is there a chance that that kind of a tactic by the State Attorney General of Vermont is going to be successful in deterring or at least stopping some of the perceived abuses that are out there?
You know, I'm unclear because generally the patent law has federal preemption. However, clearly the states are signaling, and trust me, Vermont's not the only state that's interested in this area. So clearly the states are, or, you know, actors are impressing upon their state governments that something needs to be done to curtail this area. And so I suspect that something will happen eventually to reduce the amount of patent assertions, which is why I said this won't in the end stand.
Hi there, I'm Charles Dwan with Public Knowledge. So this question is for Ms. Kimmel, and you know, you were talking earlier about how we're really in the dark about a lot of the information about, you know, settlements and particularly pre-litigation settlements where we just don't know how much of them there is or what's going on with them. And I know since there's a lot of interest in transparency with patent ownership these days, what sort of information you think would be the most useful to have so that you can fully conduct a fully informed investigation of these sorts of issues?
Well, I mean, you know, I think one of the questions that's been asked is whether, you know, essentially what's going on underneath the surface, underneath the tip of the iceberg, and that's, you know, we just, you know, without, you know, that's not public information. Now, but, you know, in my own opinion too, though, you know, I mean, doing study, I mean, there's costs to doing studies too, so it's particularly important that we really have a very clear, it seems to me in any event, that we have a very clear direction as to what we're trying to understand and why, and what kind of question, you know, what kind of, you know, what we're really going to add to the dialogue again too. So I think those are the kind of questions that the agencies, you know, are really, you know, would really need to focus on, exactly how we can really contribute to this discussion.
Yes.
Hi, I'm Russ Marbeth with Intellectual Ventures. Question for Ms. Kimmel. In terms of the FTC investigation, to a point that...
Well, it's not in...
I'm sorry.
I did the words a little loaded.
Okay. To the FTC inquiry. As Lonnie alluded to, it's not impossible that some of the rise in litigation is a result of a rise in infringement. And I'm curious, there's been reference to the drag on innovation that PAE activity might impose. Is there any concurrent thought by the FTC of looking into the potential that infringement is actually posing a drag on innovation and a drag on the economy?
Sure. No, I mean, we would want to, of course, take a very balanced approach, but I also think we did look at that a little bit in the 2011 report. We devoted a lot of attention to problems of patent notice, and I think, that's, so we have started to really think about whether, the challenge of actually identifying patents in advance of investing in R&D and product development. So I think we have started to take a look at that issue, but it would of course be part of the question, because you're looking at overall cost-benefit analysis on innovation, then of course that's something we want to think about too.
Just a comment before the next question on the question of the secrecy of settlements. Of course, I mean, settlements are not, there's nothing prohibiting settlements from being announced. It's by contractual agreement of the parties, and typically we would love to announce our settlements. For obvious reasons, a lot of companies that were sued and are settling don't want to disclose what they paid essentially for a license. So, and that, that's understandable. They don't want their competitors to know, and they have various reasons for not wanting that to be disclosed, but it's certainly not us, and there's nothing about the law that would make settlement secret.
I wanted to drill down on the question of the distinctions between what you would call privateering, which is companies that are operating companies selling their patents to assertion entities and having them assert them rather than the companies themselves, and entities like RPX where they buy up patents and they're there for defensive purposes when there are patent suits asserted against the companies that own those patents. Is there a distinction in terms of the problems that might exist from an antitrust perspective and also from a sort of drag on innovation perspective? I'd be happy to open that up to the panel for any comment.
Well, in terms of so is there a difference? A little bit. The companies like RPX versus, say, AST, which is more of a consortium. I mean, RPX, it's a public company, so it needs to make money. I assume, but perhaps I'm mistaken, that someday they will start selling the patents that they've purchased for their members on the open market, and then other people will be sued by those patents. I assume, but I could be mistaken. Whereas AST buys them up, I think, and just holds them. I'm actually waiting for the day when someone forms an entity that buys patents and just simply writes the patent office a letter saying, we disclaim all the remaining term of this patent, so they kill them. There isn't a patent kill organization that I'm aware of, but I'm waiting for the day when someone starts one.
Have some fun naming them. Other thoughts on that question? Any further questions from the audience? One more?
Hi, Dan O'Connor with CCIA again. One more question for Lonnie, but then just because you're the representative of the monetizers up there. A lot of my member companies, big and small, and we represent a wide variety of technology companies, complain about the monetizer, in loose terms, like a protection racket, whereas you might not sue somebody on them, but wink nod, if you don't buy our license, we can put this in the hands of a more litigious, smaller company. And I'm not sure to the extent that Intellectual Ventures does that, but it certainly exists in the marketplace. I believe it was Tom and Robin's paper that identified, I think, IV as having 1,300 shell companies. So does that I think you said you filed 16 lawsuits, does that include your subsidiary organizations? And also, can you disclose, it can be raw percentages, like how many of the assertions, how many rights do you have? Because I know there's some contractual structures where if somebody sues, you sell the patent to somebody, they sue, and you get a right to the litigation. Is that a common sort of a contractual arrangement that you enter into? Because it's kind of opaque the way this market operates to a lot of my member companies.
Sure. The 16 are just lawsuits we filed in our own name. And we have a lot of patents. We have disposed of a number of them. By percentage, though, very small amount. I mean, we've had very few divestitures, and obviously once we divest a patent, we don't have any control over what the buyer does with it. And it's not something we talk to them about when we're selling it to them. We're just trying to raise money. And there are some instances where we have a so-called back end, and some where we don't. It just depends. But again, we don't dictate what they do with the patent any more than in any other transaction where you sell property to someone.
Any further questions? Oh, we're a little bit over our time, but not as much as I thought we would be. So I want to thank you all for joining us today, and certainly if you have any questions from the panelists, you can speak with them afterwards. And If there was anybody who was online or here that might want to watch the program again or share it with colleagues, we should have it up online a little bit later today. Thank you.